The wheel of justice may grind slowly, but it will surely get to its destination of undiluted justice. But while you wait for justice, have you imagined how that long-drawn case can be settled out of court? Yes, we mean rebuilding a culture of amicable settlement of disputes through alternative dispute resolution. Settle with Laughter is a program tailored to educate, inform, sensitize, and promote access to justice through alternative dispute resolution anchored on mediation, consensus building, restorative justice, negotiation, and arbitration. Join an alternative dispute resolution expert, Barrister Ben Odoh, on Settle with Laughter on Soul TV, Abakaliki. Settle Dispute Television is an initiative of Negotiation Powerhouse Company Limited.
Top of the moment to you and welcome to this platform where we are definitely having only the intention of making the future brighter by gathering messages, gathering information that we build to make it better tomorrow. That's because we want a peaceful tomorrow for even the unborn generation. My name is Chika Igwe and this is Settle with Laughter on Salt Television. With me in the studio today is the PA Technical to the Deputy Governor of Ebonyi State and a very regular resource person to this program, an ADRS part. I welcome you here, Barrister Ben Odoh Uruchi. Thank you, sir, for coming.
Thank you for thanking me. Good morning, viewers.
Okay, and for you who will always be there for me, we definitely and very, very sincerely appreciate you. For all our fans, the comments are various here, and we may not go through all of them, but I want you to know that we recognize your contributions, we recognize your commendations, and we are happy that you're there, because if you're not there, our stay here is actually useless. So thank you for always commending us from wherever you have been commending us from. We do not intend taking you too far away from the real business of the day, because we've got to find out that most of the time before we really speak jack, and the time will be over. We have been onto the advocacy, and we want to, last week, sir, we looked at the impeachment of an award, and that's exactly where we are on to now in the arbitration advocacy. And I want to ask you, okay, you gave us instance the other day that within a certain period of time, I would want you to get back to that a little before we move on, that if a judgment is delivered or an award is given, that within a certain period of time, we or the contenders have the opportunity of applying for impeachment of that award. And what exactly did you say is the time again before I get into the next one?
Thank you very much, Chika. Thank you very much, viewers. I think you asked me last time I was here, and I told you that the time limit for impeachment of an award is 3 months.
Okay.
If an award is given and a dissatisfied party, a non-successful party, intends to impeach the award, that's to say, impeachment is just attacking the award or challenging the award with the view of making the award ineffective, invalid. If you intend as an unsuccessful party to challenge an award or to attack the award, which is the impeachment of the award, the statutory provision for this impeachment is 3 months. Okay. And it is provided for under Section 29, subsection 1 of the Arbitration and Conciliation Act. If after 3 months you decide to run to court to impeach the award, the court will not listen to you because it will be deemed that you have slept over your rights.
Okay.
So it must be within 3 months. A day after 3 months, it will be overruled that you did not raise such impeachment timelessly. So it must be within that specified period of time by the act, which is 3 months. Remember I told you that equity helps the vigilant and not the indolent. So you must timelessly impeach an award if you intend the award to be declared invalid and non-binding by the court.
Okay, thank you so much. I think the most important information I really want to get out of it here is what's the duration? And you have said if it is not timelessly done, I like that English, if it is not timelessly done, then you don't consider yourself worthy or qualified to impeach the award again, because equity will always
help the vigilant and not the indolent.
And I do know you're not going to be the indolent party to these arbitration rules here. So fine, if either before or after this grace or window period where we can impeach, supposing at the end of the day an award is not impeached, what follows?
Thank you very much. If an award is not impeached, what follows is, now the person who applies for an award to be impeached is an unsuccessful party, because a successful party will not go to court to apply that the award be impeached. So it is the unsuccessful party that will apply to the court for the impeachment of the award, so that it will not be valid, so that the favored or the successful party will not have something to fall back to. Now, if an award, remember the last time I was here, I told you that once an award is made, an unsuccessful party has 3 options available to him. Number 1 is either to accept the award in good faith and for value, or number 2, to use that as basis for negotiation.
Yes.
Or number 3, to apply that the award be impeached. Now, if he fails to 1, accept the award in good faith and for value, or use it as basis for negotiation, or impeach the award, then it is now the duty of the successful party to apply to the court for recognition and the enforcement of the award. Remember what I've said. He has these 3 options, and he refused exhausting any of these options, and refused carrying out the award. I am asked, 2 of us are into commercial relationship, and along the line there is a breach resulting to commercial dispute. And we have appeared before an arbitral tribunal who gave an award against me to pay you 10 million. Now in this case, now I have 3 options. Either to accept to pay you that 10 million in good faith and for value, or 2, I can use that basis for negotiation by saying, Chika, I don't have 10 million, no, I have 8. Please bear with me. Even if you go to court, I can't get that 10 million. You can say, okay, no problem, my brother, I'll bring the 8 million. I have used that award as basis for negotiation. Yes. Or 3, I can ignore the award and rush to court to tell the court, please, don't recognize this award. I want to impeach it. But if I fail to do these 3, and I also fail to pay you, I refuse accepting the award, I refuse using it as basis for negotiation, and I refuse impeaching the award, and I refuse carrying out the award, what has been awarded, which means I decided to keep mute. I decided to keep quiet over it, not exhausting this option and not carrying out the award. The successful party has the duty to rush to the court, to apply to the court that the court should recognize and enforce the award. That is 1. So if an award is not impeached, the next thing is for the award to be recognized and enforced by the court. Now, a successful party has this duty to rush to the court that the court should recognize the award. Now, that recognition is a defensive process. Or, alternatively, if you perceived that a dissatisfied party, an adverse party, intends to impeach the award, you can, as a successful party, rush to the court to ask the court to recognize the award so that that adverse party may not impeach it. So there are two things here now. Number one, if he fails to do that, and he fails to, the dissatisfied party fails to impeach the award, a dissatisfied party fails to recognize the award, fails to carry out the award, he fails to use that as basis for negotiation, he fails to carry the award, to accept the award in good faith and for value. Now, a successful party has the duty of going to court to impeach the award, to recognize the award. That is one. Then two, assuming that you have perceived he has not impeached the award, a dissatisfied party has not impeached the award, but you are perceiving likelihood of impeachment of the award by a dissatisfied party. A successful party has this duty to do what? To ambush the dissatisfied party who has the intention of impeaching the award by rushing to court to ask the court to recognize the award. Are you know what I'm saying? So that if the dissatisfied party comes to impeach the award, he will have nothing to impeach because the court have recognized the award for enforcement.
Now, before I really get into the point where I would want you to tell us about recognition and enforcement of award to differentiate it.
Yes.
There's this stuff you just said now that I really need to, I want you to make it clearer. Okay, now the duration, the window period is 3 months.
Yes.
After the award has been given. Okay, we have as much as 3 months for us to wait, or for the court to wait. If the award is not impeached, then the next actions, which you said is recognition and enforcement, will now take place. Fine. If for any reason, like you said now, if the satisfied party envisaged that this guy might want to go and impeach this, that he has, I don't know, is it still fair on his part for him to ambush, that is, supposing the court allows him to ambush the man so that he wouldn't want to do, is it still...
No, when you rush to court, you're asking the court to recognize the award.
He should have waited, because if he gets to the court, I am thinking that you wait now, let the 3 months go, you come back. If he fails to do it, and if he impeaches it, then let's look at the point he is making. We want to make this here.
No, if you go to court, and then ask the court to recognize the award, now the court looks at your prayers and see whether the award is recognizable and enforceable. If it is just and equitable, they will recognize it. Not minding that it is the duty of it is the duty of the unsatisfied, the adverse party, unsuccessful party, to apply to the fact that, like I said, is a defense process. Like I'm saying,
yeah.
It is a pragmatic and positive step against declaring an award invalid. The fact that you have asked the court to recognize it does not mean that the court, if there are reasons for it to be impeached, that it cannot be impeached. It can still be impeached, but you already have a defense mechanism, are you going to say, against any plan of the unsuccessful party. Okay. I don't know whether you agree what I'm saying. So it's not that once you rush to the court and ask the court to recognize that the award, and the court now discover at the end that is not recognizable, they will reverse it.
Okay, yeah, I do know that you will have your ways of, treating these cases, but I was kind of being of the opinion that they should allow this window period go. He should be patient enough. Let the window period go, except he has skeleton in his cupboard. But that's by the way. Because I do know that it's an orderly place. The court is an orderly house. So they actually know the processes to go by this. But like you've just made it very, very clear. Fine, that the fact that he had decided to ambush the award doesn't mean that it must be accepted by court. He will still go through other protocol
just a defensive process
to make sure that he doesn't have something against the award.
Very well.
Okay. Now, if that be the case, can you differentiate when you say to recognize an award and to enforce an award? I'm somehow not very, very clear. Can you give us the difference between this recognition and enforcing it, and then let's get to appreciate it more.
You see, recognition and enforcement of award are two different things. The people use it interchangeably. The two words, recognition and enforcement, they are not the same. They use it interchangeably. In fact, the Geneva Convention of 1927 expressly distinguished between recognition and enforcement. Now, the difference between recognition of award and enforcement of award, according to this Geneva Convention of 1927, is that in recognition of the award, you are asking the court to do what? To acknowledge, ratify, and accept an award that is done on their behalf. Are you know what I'm saying?
Yes.
With the authority. Now, in a layman's sense, recognition simply means the process of ratifying, the process of acknowledging,
Okay.
the process of clarifying that what is done by someone in someone's name has someone's authority. Did you get that? It's a process of accepting, it's a process of rectifying, it's a process of acknowledging that what is done in someone's name for someone has that someone's authority. So now in arbitration, in award, when you go to court for recognition of award, remember I told you before that the court is an agent, is an undisclosed principal. The arbitral tribunal, the arbitrator, is an agent of the court.
Okay.
Are you know what I'm saying? The arbitral tribunal, the arbitrator, is an agent of the court. They are representing the court. Remember I told you that arbitration is a privatized judicial process. The judiciary decided one day to privatize one of their functions because they had so much enormous responsibilities. So they decided to privatize one of their enormous responsibilities to private individuals. Now, from private individuals subscribe to that privatization to assisting the court carry out one of their responsibilities, one of their functions, and that function is resolving commercial disputes. And these people that are helping the court, assisting the court in resolving this commercial dispute are called arbitrator or arbitral tribunal. So the court is their principal, is their boss. So whatever they do, they have the authority and the permission and the leave of the court to do that. Anything they are doing it on behalf of the court. So when a dissatisfied party, when a successful party in arbitration proceeding goes to court to ask the court for recognition of the award, what the successful party is doing is saying, the court, I am here to ascertain whether arbitrator Chika actually have your permission to represent you, because he told me in a proceeding that he represented you. I am here that you may acknowledge that representation. So when a successful party is before the court applying for recognition of the award, what are you doing? You are before the court asking the court to do what? Acknowledge. Asking the court to do what? Rectify. Asking the court to do what? Accept that the arbitral tribunal has their authority in doing what they have done. I don't know whether you agree I'm saying that. So recognition of the award is an application to the court that the court may clarify, that the court may acknowledge, that the court may accept that the arbitral tribunal has the authority to give the award or to preside over the proceedings.
Okay.
Once the court accepts that, yes, he has our permission, the court will now declare the award valid and binding. I don't know whether you agree what I'm saying now.
Right.
So in applying that the award be recognized, you are asking the court, if truly the arbitral tribunals have represented your interests with your authority, now declare that this thing is valid and enforced and binding. Now it is the duty of the court to say, yes, the arbitral tribunal, they have our authority. The award is hereby valid. And because it is hereby valid, it is binding on the two parties. Now the difference between recognition and enforcement, in recognition you are only asking the court to declare the validity and the bindingness of the award, having acknowledged and ratified the award as. You know, when you go to court now, that award will now cease from being a private document to becoming a public document. Because that award becomes the judgment of the court, because the arbitral tribunal represents the court. So in enforcement, the difference between a recognition and enforcement is that in enforcement, you are not asking the court to declare the award valid and binding. You are asking the court, after declaring the award valid and binding, give an order that the award be carried out using all legal sanction at your disposal. That is enforcement. Two different things. Recognition, yes, just the court, is the duty of the court to merely declare that the award is valid and binding. When you go further to apply for enforcement, you're asking the court, now that you have said this award is valid and this award is binding, because the arbitral tribunals had your authority to act on your behalf. Now please use all the legal sanction at your disposal to make sure that this is carried out. I don't know whether you're going to say.
Okay.
So in recognition, you are asking the court to give legal force, to give legal effect to an award. In enforcement, you are asking the court that this legal force and legal effect be carried out. Let it be implemented. Let it be implemented. Let it be carried out. So enforcement is an execution of law. Enforcement is carrying out something that have been carrying out something like command, or carrying out something like an order of the court. So in enforcement, you are asking the court, please, now that you've declared this thing, how can I get these things you have declared? The court will now say, okay, now let us. Sometimes the court can use all legal sanctions within their disposal, such as they can use what we call FIFE, writ of FIFE. They can use what we call garnishee proceedings. They can use what we call summon judgment. I give you an example. Now, if I am the creditor, and you are the debtor, and then an award has been given against you, the debtor, to pay me, and I have gone to court to say, recognize this award, and the court have recognized this award, and you don't have physical cash to pay me. Are you going to say, because you're a civil servant? Now it is my duty to ask the court, use all legal sanction at your disposal to compel checker to pay me. Now the court may say, okay, what are we going to do? The court may give EBBC order. Any salary from now till December that is accruing to checker, transfer it to Ben's account to raise that money. We'll call it FIFE proceeding.
Okay.
The court can do that. And then, because you don't have physical cash to pay me, EBBC will now be paying me your salary until I raise the actual amount, until you reach the actual amount you are owing me. Or the court can use a process called garnishee proceeding. In garnishee proceeding, it is a form of, oh, you don't have the physical cash, but you have properties. They can seize your land and sell it and get my money, assuming that you're owing me 5 million, and they say the land 6 million. They will say they get their property, auctionize it, and then from the 6 million, they'll give me 5 million and return the balance of 1 million to you. It is a legal sanction from the court. Are you know what I'm saying? Or someone judged me. So the court has all legal sanction at its disposal. So in enforcement, the successful party is asking the court, use these legal sanctions you have. Use it to make sure I get what has been awarded to me. So that's the difference between recognition and enforcement.
Now, is it possible to recognize an award without enforcing it?
Yes.
I should have said the same thing. By the time you want to recognize the award, you're also saying, okay, they have our legal backing to do all this. So they should have all the authority to go ahead. So,
the applications are two different things.
That's what I'm saying.
Yes.
Why do we need to duplicate all this?
No, that's what I'm saying. I give you the court. Like I said, you are asking the court for two different things.
Mm-hmm.
I can say you're asking the court for two different things. If you're asking the court for two different things, then you need to say two different prayers.
No, what I'm saying is, okay, the actual thing that led us to the arbitration court or to the arbitration tribunal is that, okay, I am owing you. Okay, we are business partners, and so along the line, there was a breach, and you took me to the arbitration tribunal. Okay, who already have the backing of the court. They are the agent of the court that discuss business issues like this. Fine. At the end of the day, the tribunal have said, young man, you're wrong. Balance this person so and so amount. I will still, they will now require that you still go back to tell them that we are finished to, and since we are finished to tell this man that what they said in the tribunal is correct. And at the end of that other application, I'll be expected to come back again and tell them, okay, you have said that it's correct, fine. Also tell him again that he should pay. Is it not duplication?
No, it's not duplication. The court has a laid down procedure.
And unnecessarily time consuming.
It's not unnecessarily time consuming. Now, sometimes you cannot go to court, you cannot leapfrog, you cannot go to court to ask us to enforce what is illegal.
Yes.
Number one is you must make it legal first. Before you now say the second prayer to ask the court, now that you have said that this thing is legal, enforce it for us, let it be carried out. Are you going to say? Because the court cannot give an order that an award be carried out when the court have not received the award, when the court have not recognized the award. There must, first of all, you cannot put something on nothing and expect it to stand.
Okay.
There must be something that will hold what you are putting on it. So the first is, the award must be valid. And party A will know that, oh, this thing is valid though. Party B will know that this is valid though. Before you will now say, okay, the court, I am before you. This thing is valid. Now, but this person refuse, carrying out these things. Please compel him to carry it out. Do you know sometimes parties go to court and apply that the court recognize the court. Now, if the adverse party if the other party discovers that, oh, the court have said it's valid, they will just tell you, okay, don't worry, because the court have declared it valid, I'll pay you. That ends it. But if after declaring it valid and he still refuses, you now ask the court to assist you. It's the last hope of a common man. And okay. They can assist you.
Time is really ticking, and we need to go for a little break now. But before then, I would want you to quickly look at this, because I actually want us to work on these enforcement and recognitions for today. Where exactly is this application going to be made? Is it going to be at the arbitration tribunal or in the court now? Where is the place for the application?
The application for recognition and enforcement of the award can only be made in the High Court, in the court. Now, Section 57, subsection 1 of the Arbitration and Conciliation Act of 2004 gave a definition of a court. And it says that the court for the purpose of arbitration proceeding means three things. Number one, State High Court. Number two, Federal High Court. Number three, High Court of FCT, Federal Capital Territory. So if you are going to apply to court for recognition and enforcement of the award, it must be either in this any of these three courts, either the State High Court or the Federal High Court or High Court of FCT. You cannot go to Court of Appeal, you cannot go to Magistrate Court, you cannot go to Customary Court, you cannot go to Supreme Court. It's in either of these court. But anyway, the subject matter will determine either of these high courts, either the Federal High Court or the State High Court that you can go to.
Okay.
There are some matters, because you're expected to go to any of these courts wherein the subject matter is what either of these courts would have ordinarily had original jurisdiction to entertain the matter, but for the parties opting for arbitration proceeding. I'll give you an example. Under section 251, subsection 2, subsection 2 of the 1999 Constitution, as amended, there are some matters that are listed there that gave the Federal High Court exclusive jurisdiction. That's to say, these matters cannot go to State High Court. So when you have issues and your issues borders on any of these matters listed in under section 251 of the 1999 Constitution, the only court that you can go to enforce the award is the Federal High Court. I'll give you an example. Under that section 251 of the 1999 Constitution, issues bordering on taxation cannot go to State High Court. Especially taxation with the federal government, it must be in the Federal High Court.
What if it is the state government? That's what I was about to ask you. If taxation bordering on state government, why wouldn't it go to State High Court?
That's what I'm saying. If it has to do with taxation with federal government,
okay,
then Federal High Court. But if it's with state government,
it should be the state.
Then issue of company cannot go to State High Court. Company proceeding, any issue that is in comma, whether it's business name, whether it is incorporated trustees, whether it is company limited by shares, company limited, anything